Good morning. Welcome to JK Shah in association with Best Academy to our video classes. I am Ramakrishna Shastri, advocate and professor. Today, let us take up the famous case Solomon versus Solomon and Company Limited. All of you know that the famous five-member judge in the House of Lords, headed by Lord McNaughton, the judgment was delivered. And the outcome of the judgment, the principle established by the judgment, was just in one line: company is a separate legal entity different from its members. This was delivered in the year 1897. Most of us do not know that in India, in West Bengal, a case was held in the year 11 years earlier to the Solomon case. The name of the case is Kondali Tea Estates Limited, 1886. What is this case about? Now, you know Darjeeling is famous for tea. There were a lot of tea estate owners in Darjeeling. Some of them were big tea estate owners, some of them were small owners. They all decided to pool all their estates to form a company in the name Kondali Tea Estates. They transferred all their tea estates to the company after the formation of the company, and for the value of their respective estates given to the company, they took equity shares. So they became joint stockholders of the newly formed company. Now, the registrar of firms or sub-registrar of West Bengal, he said, you have transferred it to the company. It constitutes sale and therefore you have to pay the stamp duty. Unless the stamp duty is paid, the transfer is not valid. Now, all of them went to the court against the orders of the sub-registrar, and they argued in the court saying that we were the owners of the tea estates, we formed a company, we transferred all the tea estates to the company. In effect, we have transferred all the tea estates to ourselves. So how can we be the seller and the buyer at the same time? There is no sale. When we transfer to ourselves, we are not buyers, we are not sellers, we are one and the same, and therefore there is no question of sale. If there is no question of sale, there is no question of payment of stamp duty. Now the judge held that once a company is formed, it is a separate legal entity different from the members, and therefore company is one entity, the members are different entities. Any transfer from the members to the company constitutes sale, and therefore the company is the buyer, the members are the sellers. When there is an immovable property transferred from one person to another, it is incumbent on the part of the seller to pay stamp duty. Therefore, stamp duty has to be paid. So, 11 years before the Solomon case was decided, in India, a judge had taken a stand that once a company is formed, it is a separate legal entity different from the members. It is really unfortunate that none of the textbooks or study materials of any institute has a reference about this case law. I hope you understood the principle behind this. Thank you very much, and let us meet once again in a different video.